Nadine Strawson, welcome to the show. Thanks for joining us.
I'm so delighted to be here, Ilan.
I thought I'd start with just a brief bio about you so we can introduce you. I'm familiar with the work. I've read your book that we're going to talk about, Hate, Why We Should Resist It with Free Speech, Not Censorship. And I'd like to dive into that. But just a bit of background about you. So you've been teaching at New York Law School for many years, and you have emeritus status. Just before we started recording, you mentioned you've stepping back into the classroom. I'd love to talk more about that as we get in. I believe you also, for a long time, the past president of the American Civil Liberties Union.
Correct.
And I think that the most recent president, right? So
the most recent immediate past president, right?
I've seen your work in many places, and I recognize you as a leading expert on the issues of free speech. And I've seen you speak, and I've read some of your work in addition to the book. And one thing I would say is that you're really involved in this space of free speech. You're on the board of a number of organizations, among them the Foundation for Individual Rights and Education, which have helped me out in a number of cases when I've been on campus. Heterodox Academy, which I believe is spearheaded by Jonathan Haidt, and the National Coalition Against Censorship. And the other thing I read about you, which I really stood out to me, was that you were named by National Law Journal as one of the 100 most influential lawyers in America. So congratulations on that.
Thank you.
So one thing I wanted to start with is to sort of situate this debate about hate speech that we have. One thing I've seen, and this keeps cropping up, there was a piece in the Washington Post not that long ago arguing, the headline captures the argument, why America needs hate speech law. And there are perennial calls for hate speech laws in the US. We don't, as far as I know, we don't have any in the US. We do have speech codes on campus, which is a slightly different case, but we don't have them. And often people come into this with, I think, a sensitivity to what happens to the people who are the subject of what is often called hate speech. I'm going to put that in air quotes once with the understanding that throughout the conversation it's that way. So there's a kind of perspective that this is an undesirable thing, and we can learn from other countries that have hate speech laws and that we should adopt them, that we should bring that to the US. And one of the points you make in your book really found helpful is that you look at other countries that have hate speech laws and you study. I think you left no stone unturned as far as I could tell in terms of analyzing different laws. So I wonder if we could start by looking at some of those laws on the books, but I think maybe the obvious question to begin with is, what is the legal definition of hate speech?
Okay, first, if I may, Ilan, I want to show the full title of the book. Hate is the main title, but the subtitle is Why We Should Resist It with Free Speech, Not Censorship. Because I think what the relevant comparison is between the United States and other countries is all of the non-censorial measures that we use in this country to counter hatred and stereotyping and discrimination. And my conclusion, as well as that of human rights activists from many other countries and international organizations whom I cite in my book, the conclusion is that those non-censorial methods, including education and debate and discourse and anti-discrimination laws, that they are all more effective than censorship in the essential business of reducing hatred and discrimination. The concept hate speech, and I'll do the air quotes once and then please assume them from now on, it is not a legal term of art, not only in the United States, but even around the world. Many countries that outlaw what we think of as hate speech, namely speech that conveys hatred or stereotyping or discrimination on the basis of identity, race, religion, gender, sexual orientation, and so forth. Even countries that outlaw that kind of speech generally don't even use the term hate speech. It's what tends to be used in everyday parlance, but it has no single agreed upon legal definition. In fact, in the United States, to the contrary, the Supreme Court consistently, persistently, with a broad consensus across all of the justices, despite all of their disagreements on many issues, they all agree that there should not be a hate speech exception to the United States constitutional protection for free speech in the First Amendment. So for that reason, they've never had to define a category of speech based on its hateful content and say, therefore, it is unprotected under the Constitution. In fact, if you look at how the term is bandied about by politicians, by folks who are running social media platforms, by the public, by Twitter mobs, etc., it really comes down to whatever the person or group using that stigmatizing term, whatever speech they hate and consider to be hateful. And no two people can possibly agree. In fact, one person's so-called hate speech is somebody else's loving speech. And I give many, many examples in the book, but we're recording this on the last full day of Donald Trump's presidency. So let me say that many people wear his name on caps and on t-shirts with great love, with great pride, with great affection for him and his ideas and his policies. And yet that very same word, when chalked on sidewalks and college campuses, has been attacked as hate speech. Black Lives Matter is a movement that many people see as promoting the loving, inclusive kind of message in the spirit of Martin Luther King, whose birthday we just celebrated. Other people have denounced Black Lives Matter as hate speech against white people, against police officers. Some people see all lives matter as the most loving message, and yet other people have attacked that as hate speech against Black people. So given the inherent subjectivity of this concept, the only way to preserve individual freedom of speech in terms of what we say, what we choose to say, and what speech we choose to receive, what ideas and information we choose to receive, we have to leave that decision up to each individual. And we can't delegate it to any government official. And I would say we should not delegate it to powerful social media companies either.
Interesting. I'd like to, maybe we can come back to the social media side of it later on. When you were describing how this term is inherently subjective, and what brought to mind is a few of the examples that you put in the book that really stood out to me. So one of them, I'll just, maybe you can fill in some of the details, but so I was particularly interested in the countries that are closer to the US model. Yes. So thinking of the UK or Canada or some of the Western European countries. And I think this is an example from Canada, where there is some sort of hate speech law on the books. A man was charged with distributing flyers, or 4 different flyers.
Yes.
This went through, I think, 4 levels of judicial processing, different courts, different experts. Tell us what happened in that case.
Thank you. It's a classic example. And Canada has multiple hate speech laws, I should say, because like the United States, it's a federal system. So there's a national law and each province has its own laws. So this was a famous prosecution of a gentleman who was distributing pamphlets that he would say were loving. They were quoting Bible verses, and he was preaching against homosexuality heterosexuality, as he called it, because he believed that people who engaged in that kind of sexual contact were committing sin and they would be damned to hell. So by trying to persuade people not to engage in conduct that he thought was going to condemn them to everlasting hellfire, that was actually a loving thing to do from his perspective. Putting that aside, there were, as you say, 4 pamphlets and 3 levels of judicial review. One found that all 4 were punishable hate speech. One found that none of them was punishable hate speech. And one found that 2 of them were and 2 of them were not criminally punishable hate speech. So here we're talking about legal experts applying the very same law to the very same documents. And Elan, that was so typical of cases that I studied from other comparable democratic countries. Of course, the laws are, at least they're even more abused, tend to be more subject to abuse in countries that don't even have democratic controls. But even with democratic controls and the rule of law and due process, which certainly exists in Canada, the results are inherently arbitrary at best and discriminatory at worst, because the laws give essentially unfettered discretion to whoever has the power to enforce them, whether it be a police officer or a prosecutor or a judge. And even if people are acting in the utmost good faith, there is no objective way to enforce these laws. And if I may say, the long history of U.S. free speech law, which starting in the middle of the 20th century, started to really become speech protective. For most of our history, starting in 1791, when the Bill of Rights, including the First Amendment, was ratified, we had freedom of speech in theory, but not at all in reality. We had a long pattern of censorship, especially of those who were challenging the status quo, including abolitionists and civil rights activists and women's suffragists and anti-war protesters and socialists and fascists, anybody who, not in the center of political power. And it wasn't until we started putting teeth into that free speech guarantee, specifically by limiting the amount of discretion that enforcers had to separate punishable speech from unpunishable speech. Essentially, the court said, starting in the second half of the 20th century, that only in an emergency situation can government punish speech, when the speech is directly, imminently causing certain specific, serious harm. And the only way to avoid the harm is through censoring speech. You do that as a last resort. Before that, we had this so-called bad tendency test, which is very much what other countries have in the form of hate speech laws, when speech might potentially, indirectly, at some point in the future, perhaps lead to some harm. And it's that rationale that undergirds all of the hate speech laws in other countries, and why it is completely unpredictable and arbitrary at best who's going to be punished, and discriminatory at worst, because there is the opportunity to enforce these laws specifically against unpopular speakers, dissenting viewpoints, members of minority groups. And we've certainly seen that in countries that are not democracies, but we've also seen it in advanced democracies. When the United Kingdom adopted its first hate speech law in the mid-1960s, in order to protect racial minorities, the very first people who were prosecuted were themselves members of racial minorities, including when they were criticizing police officers and other government officials for engaging in racism. When Canada adopted one specific version of a hate speech law that punished certain sexually oriented expression, they used the term pornography, that was allegedly demeaning or degrading to women, the immediate victims of that censorship were a lot of books by feminists, and particularly books by and about lesbians. There were at that time in Canada quite a small number. I was shocked to learn of lesbian gay bookstores across the country, and most of them were driven out of business by this law, which was supposed to be helpful to those who were traditionally disempowered, but not surprisingly, predictably, was enforced by the powers that be against feminists, against lesbians, activists, against crusaders for reproductive freedom.
I was struck by, I think you mentioned in the book that one reason Martin Luther King Jr. wrote a letter from Birmingham jail is that he threatened many of the beliefs of the people whose minds he was trying to change, and they didn't like that. And I think the other one that really resonated with me was the example that I think it was in the 1830s, many southern states enacted laws to suppress abolitionist publications and speech, which I think should be chilling for people today when they think about what would that mean for us if something like this were put into place, and whose hands that power would go into. I wanted to draw out a point that you make about, so one of the observations you draw from looking at these other countries' laws, hate speech laws, is that no one's ever figured out how to write one that actually accomplishes what it's supposed to, and if a law like this were enacted here in the U.S., it wouldn't pass muster. It would be too broad, too vague. There's no Goldilocks here. There's no solution. There's no just right, because it's inherently subjective. I'm curious how, just thinking, if you can bring us into the mindset of how lawyers operate and to think about law, how does that work? What kind of considerations go into writing something like that?
I want to give another example from the book, and thank you for being such a close reader, Alon. You all already mentioned hate speech codes on college campuses. So these started being drafted in the late 1980s, early 1990s, and the ACLU immediately went to court to challenge them. We won the early lawsuits, and that work has been continued. Unfortunately, the fact that something is illegal doesn't mean it doesn't happen. And so since then, there have been so many free speech battles on campus. An independent organization that does nothing but focus on campus free speech and other campus civil liberties issues, FIRE, the Foundation for Individual Rights in Education, has been bringing these lawsuits. And every single hate speech code has been found to be either unduly vague or overbroad, or both. And yet, all of these codes, going back to the very earliest, have been drafted by the legal experts that are on the faculties of those law schools, of those universities, many of which have law schools. So you have people who are the best experts trying their utmost to define the outlawed speech in terms that are as clear and narrow as possible. But once you get beyond the narrow standards that are acceptable in US law, the emergency test that I talked about, once you go beyond that and start punishing, defining speech based on its content or its idea or its message, or some vague notion that it might potentially cause harm, there is no way to cabin that concept. So let me cite an example from this very first case that the ACLU brought and won, and happened to be against a speech code at the University of Michigan. Now, it is an absolutely undisputed tenet of not only American law, but the law of all advanced democracies and the European Court of Human Rights, and internationally as well, that the mere fact that speech is offensive is not a justification for punishing it. So in this case, where the university has come up with the typical vague language that there can't be speech that's demeaning or degrading or humiliating. Those are stigmatizing. Name all the synonyms, they've all been tried. And so the judge is questioning, during the oral argument of the case, the judge is questioning the attorney for the University of Michigan. And he says, well, you're saying that we can't punish offensive speech, that's unconstitutional, but we can punish demeaning or degrading speech, that's under the speech code, and you're telling me that is constitutional. So, Mr. Attorney, how do you distinguish offensive speech from demeaning or degrading speech? And the lawyer answered, very carefully, Your Honor. At least he had a sense of humor, but it's no laughing matter. And the fact is, Ilan, when you apply the emergency test, it does allow government to punish exactly the hate speech that should be punished. That is the speech that is most likely to cause direct damage. Give a little bit more concreteness to it, the U.S. Supreme Court has identified several categories of speech that do satisfy the emergency standard. And let me make one other point here. I already said that government should not be allowed to punish speech solely because of disagreement with or disapproval of its viewpoint, its message, idea, or content. That's usually called the viewpoint or content neutrality principle. In contrast, when government may punish speech under the emergency principle, it's not looking only at the content of the message. It is looking at the message in context. In the particular facts and circumstances, does this speech with a hateful message or with any other message cause certain specific serious harm imminently? Then it can and should be punished. And subcategories of speech that meet that emergency test include, for example, what courts call a true threat, when the speech is targeted at a particular individual or small group of individuals. The speaker intends to instill a reasonable fear that our targeted people are going to be subject to some kind of violence. That is punishable. And there are many instances where hate speech does satisfy that demanding but not impossible standard. Another one that people have been talking about a lot lately in the wake of the events of January 6th, intentional incitement to imminent violence, where the violence is likely to happen imminently. There are many situations where hate speech does satisfy, not because of the content of its message, but because of the context. It's said in such a circumstance that it is intended to and likely to incite imminent violence. Then it can and should be punished.
That brings up something I wanted to ask you more about. So in reading the book, so I noticed you are systematic in putting the term hate speech in scare quotes, as we did at the beginning of this conversation. And I think you established that there's no legal sort of agreed upon definition. So I just wanted to get, if I can get more clear about how you think about this. My observation from what you present is that it's not clear to me that there is something in the world that we can designate as hate speech. Now, there are things that people regard as this, they don't like it, they find it hateful, but it's a question for me whether there is this phenomenon, because it's so hard for everyone to agree what it is, in the same way that we don't have that question when we look at, well, what is a smartphone? Like we have this new concept in the last 20 years, there's a smartphone. There might be edge cases, but we can point to it, whereas with something like hate speech, and the particular example you brought up is the one that brought this to mind. So if we take what I would think of as a textbook example of inciting someone to murder, I incite my neighbor to murder a third neighbor or something like that, and we can demonstrate that I said the words that led to the action, so I'm complicit in this. and I'm a lay person in the law, so please help me out if I'm getting some of this wrong.
So far, good.
So if I do that, and maybe I say this person's hateful, maybe I don't, maybe it's some other, I can see someone coming and saying that is hate speech, and look at how that led to incitement, and that's a reason why, and that we disallowed, not because of the content, but we disallowed because it led to this violation of someone's rights, harming this person.
But there has to be a tight and direct causal connection, right? You can't have inference upon inference and speculative and attenuated causal connection, because once you do that, you're giving the decision maker discretion, which is subject to abuse. It can be used to punish speech solely or largely because of disagreement with the idea. And that is what we are trying to prevent.
Yeah, so I guess where I would push a bit on this, just to get your view, when we talk about hate speech, I find it easier to think of it as, help me see if this is resonant with you. It's someone's claim that some statement is hateful versus we can somehow reach a consensus that it is hateful in some meaningful way. You gave lots of examples of how one person's sort of ode to President Trump is another person's hateful message. And there's a really powerful one with the Confederate flag in the book. I think this was at Harvard you gave. Is it the Confederate flag or the Nazi flag? I forget, but it's the same flag, but it's meant ironically. And so, so I mean, I'm wondering about that. How do you think of the concept of hate speech, given that it's so vague and so hard to define, by the best legal minds who've tackled it?
Yeah, I think that I would absolutely oppose outlawing any particular expression or symbol. Even, as the daughter of a Holocaust survivor, I loathe Nazi expression and symbols, but I still would not absolutely outlaw any use of the swastika or any Nazi expression for a whole host of reasons, not only because of the importance of learning history, if we are really to keep alive the zeal to fight against that kind of hateful ideology and genocidal policies, we really need to study it and examine it and bring it out into the open. And so if I understand your question, I would not make any exception to what I think has to be a fundamental principle, that government should not be able to punish or outlaw speech, no matter how offensive, reviled, hateful the idea is. I really do agree with the Supreme Court justices who have said if we hate the idea, then the response is to answer back, to refute it, to ignore it. That's where we get to what is often called counter speech, that you fight hateful speech with speech that counters its hateful ideas and its potential to lead to hateful action.
I wanted to just observe that I'm an immigrant to this country, and I'm really glad that we have the First Amendment.
I'm glad to hear that.
Bulwark, and I wish other countries took note and moved in that direction. Just as we close, I want to ask you about some of the students you encounter while teaching. And I know you've stepped back into the classroom after taking emeritus status. What are some of your impressions of students in the context of what we're seeing today with the debates around speech and free speech and so forth?
The reason I took emeritus status along was precisely because I was I was on the campus lecture circuit all over the country, and indeed in many other countries. And so I've had encounters with students at all kinds of universities and colleges all over the country, from community colleges to the Ivy Leagues and the Big Ten, you name it. And there is, my personal experience this dovetails with what survey after survey has shown, which is today's younger people have a deep skepticism about freedom of speech. They see it being exercised by powerful individuals and institutions that espouse ideas that they tend to disagree with, and they tend to be a little bit results oriented, if I may say so, in part because they didn't live through the history that I lived through, where I saw that this freedom of speech was necessary to lift voices that traditionally had been suppressed. So there's a real skepticism of letting people say things that they think are dangerous or factually incorrect or hateful. And since I do believe in free speech, I don't believe in indoctrination. And my mission is to try to lead students to understand through their own exploration and analysis that harmful as speech definitely can be, that giving power to government officials to pick and choose which speech is sufficiently harmful to be suppressed, that's even more dangerous. And, I think it's ironic that in the age of Donald Trump, where so many of the students I meet are so highly critical of him and what they see as his hate speech and his disinformation, until tomorrow, Donald Trump is the one who wields the censorial power. So if you don't trust him to exercise free speech rights, you should hardly trust him to suppress other people's free speech rights.
Yeah, it's that principle that when the views you are opposed to are disfavored, people can be in favor, can support hate speech, and when the shoe's on the other foot, it's not so pleasant and you don't know. So I think what I take from that is it has to be a principled view of free speech. We can't play favorites, and certainly not helpful in terms of what are, as you put it, the centrality of freedom in life. Well, Nadine Strossen, it's been a pleasure talking to you. Thank you so much for taking the time to join me today.
Well, thank you for having me, Alon. It's a great honor.
A few quick takeaways from my conversation with Nadine Strossen. First, if you look at countries that have enacted hate speech laws, the unmistakable conclusion is that they unleash government to silence ideas that are seen as disfavored or contrary to the mainstream or contrary to those in power. That's a really dangerous path to go down. It undermines the freedom of speech fundamentally. Second, we are fortunate in the United States to have the First Amendment. No other government that I know of has protection for freedom of speech that is as robust as the First Amendment. It safeguards intellectual freedom and the freedom of speech in particular. And it presents an insurmountable obstacle to laws targeting hate speech. Nadine mentioned that many of her students have a negative attitude towards freedom of speech, and this aligns with the wider ignorance about the ideal of freedom of speech. So it's important that we better understand and appreciate the importance of the First Amendment and the principle that it upholds. We need to work to prevent it from being undermined. One final thought about the concept of hate speech, which in our conversation today, we put in air quotes because there's no way to define it objectively. Now, clearly people disagree and people give and take offense at the views they hear. We need to be left free, however, to seek out the truth and express our ideas, including ideas and views that are controversial or offensive or unpopular. That's vital. It's part of what it means to seek out the truth and to gain knowledge about the world. Throughout history, new discoveries in science and truths about human life have often contradicted the mainstream or established views. So government's protection of freedom of speech is a positive value. And thinking about the idea of hate speech, I think there's therefore no basis in reality for trying to coin a legal concept that is so vague and arbitrary around this idea of hate speech. And doing so would inevitably hand government arbitrary power to silence dissenting, offensive, or unpopular speech.
Thanks for watching. Be sure to subscribe and ring the bell to never miss a video.